Good day. My name is Dr. Muriel Mushariwa. I am a senior lecturer at the University of Witwatersrand School of Law. I would like to do a short analysis of a decision that was made in the North Gauteng High Court with respect to the use of BBBEE compliance as a criteria for access to COVID-19 relief funding. Now, the impact of COVID-19 has meant, one, there's been a strain on our public health system, as well as creating an economic crisis due to the lockdown. Businesses have lost income, as well as many of our South African citizens losing jobs. One of the hardest hit industries during this economic crisis is the tourism sector. The Minister of Tourism recently announced a tourism relief fund, and access to this fund requires that businesses have BBBEE compliance. Two organizations, AfriForum and Solidarity, took the minister to court to argue that, firstly, the minister did not have the power to create such a criteria of compliance, and that it placed an unfair disadvantage to white-owned businesses. In dealing with the matter, the court identified basically two issues. Firstly, was the action of the minister an administrative action that needed to comply with the Promotion of Administrative Justice Act, or was the action of the minister an executive action which would be reviewed in terms of its legality? So did the minister have the power to create a BBBEE compliance requirement as a criteria to the access of funding? Now, the first point that the court makes is that there's a thin line between administrative action and executive action. But then when one looks at executive action, there are various considerations that need to be taken into account. The first being budgetary constraints, the policies of the relevant department, as well as the broad political framework within which that particular department functions. The court does make the point that the individual applications that were done in terms of access to the relief fund and the decisions with respect to those individual applications could amount to administrative action, and would therefore need to comply with the Promotion of Administrative Justice Act. The second point that the court makes is that it was not going to enter into a narrow or technical application of the relief fund, but was rather going to look at the context within which this fund was seeking to operate. The Minister of Tourism argued that under the circumstances with the economic crisis, it would lead to the closure of Black businesses and would undermine and set back the transformation that had been achieved within the industry. Now, in considering the criteria itself, it's important to take note of which of the businesses within the tourism industry would actually qualify for the relief fund. So the criteria was firstly that only a cap of 50,000 Rand per business would be available. The fund is currently made up of 200 million. So that was the limit that the minister had. The minister then stipulated that only exempted micro enterprises in terms of the tourism sector codes would be allowed to apply for this relief fund. Now, in terms of the tourism sector codes, it is only those companies that have an annual turnover of less than 5 million rand that are held to be exempted micro enterprises. In terms of the general codes of good practice, these particular entities are only required to have an affidavit stating their ownership status, affirming that they are under 5 million rand in terms of their revenue. And from that, they affirm that the information is correct and that they achieve a specific level with respect to that criteria. Now, besides that requirement, the scoring criteria used by the minister looked at basically 3 elements. One was regulatory compliance, which counted 25 points. And this looked at company registration, tax compliance, as well as payment of UIF. 55 points went to what the court held to be a functionality compliance. So was this business actually functioning? Was there money coming in? Did they have audited financials? Did the business have a profile? Who made up the business? And then lastly, 20 points was allocated to BE compliance. The court then looked at the difference between a Black-owned business, how many points they would earn, and then a white-owned business, how many points they would earn. So in terms of the tourism sector codes, if you are 100% Black-owned company, you are a level 1 company and would earn 20 points. If you are a level 2 company, that's 51% Black-owned, you would earn approximately 18 points in terms of the scoring. If you were 100% white-owned company, you would be held to be a level 4 under the EME scoring. Keeping in mind that the lowest score you can achieve in the general codes of good practice is level 8. But EMEs are exempted from having to comply with all the 5 elements of BE. But should a white-owned company seek to achieve, say, a level 2, they could potentially focus on the 5 elements, specifically the priority elements, which are ownership, skills development, and preferential procurement, to increase their level of compliance from a level 4 to potentially a level 2. The court makes the point that the difference between a Black-owned company and a white-owned company, also dependent on their compliance, would be the difference of 8 to 2 points. And the court held that this was not creating an insurmountable disadvantage on the part of the white-owned businesses. The court asks the question that other relief funds also request and give priority to businesses that are owned by women, the youth, as well as people with disabilities. But the applicants in this case had not looked into those particular criteria or even questioned those particular criteria, but only looked at this particular criteria placed within the Tourism Relief Fund. And the judge held that if it is acceptable for business entities to be favored on gender, youth, and disability, then why not on the basis of race, given the multi-dimensional nature of past discrimination and disadvantage? Now, if we look at the context within which this particular decision was being made, certain points need to be made. Firstly, that COVID-19 has magnified the fault lines of disadvantage within society. So vulnerable groups are being race, gender, youth, and persons with disability have suffered disproportionately more than other groups. And this is a point that the judge makes throughout the judgment itself, that we need to look at the tourism codes within the context within which they are being applied. This is not to say that white-owned businesses are not going to suffer in terms of the economic crisis, that loss of jobs is not going to occur. But going back to the point of the minister, that whatever progress in terms of transformation had been made, it would be a setback if there wasn't an attempt to assist Black-owned businesses. Last year in April, the General Codes of Good Practice were amended, and a transitional period was given to sector-specific codes to change in terms of the General Codes of Good Practice. So the sector codes needed to align themselves with the General Codes of Good Practice. So it is interesting that the timing of this particular transition was between the 1st of June 2019 and the 30th of May this year. So it gave the tourism as an industry enough time to align itself in terms of compliance. What I find interesting is the issue around EME affidavits. So you could simply type in the word EME affidavit on a Google search, and you would be able to download that particular affidavit. So there's no cost incurred by businesses to stipulate whether they're a level 1, a level 2, or a level 4. If a white-owned business wants to increase its BEE level, then it would use the QSE, qualifying small enterprise requirements, to then be audited and see if they can improve their BEE level. The issue that I have with EME affidavits is that they can easily result in fronting. So this is a misrepresentation of the actual ownership, the actual revenue of the business itself, because once you have the affidavit, you go to a commissioner of oath and you have that EME affidavit stamped. I'm hoping that in the process of these applications, that the tourism department will hopefully scrutinize each application, but it would be interesting to see at the end of the exercise, at the end of the funding itself, a kind of audit to see which of the companies did actually receive funding from the Tourism Relief Fund itself. It's obviously important to note that this decision is potentially going to the Constitutional Court, and we will then see what will happen at the Constitutional Court and whether they will agree with the decision of the North Gauteng High Court. Thank you.